Repairs and maintenance. Repairs and maintenance issues are among the most common in tenancy law. The Residential Tenancies Act of the Northern Territory outlines rights and obligations regarding repair requests, which can include problems such as a broken toilet, marks on the wall, and cracks in tiles. In the Northern Territory, there are two types of repair and maintenance problems: emergency repairs and ordinary repairs. While the Residential Tenancies Act provides that verbal notification of a repair or maintenance problem is adequate, a tenancy agreement may vary this to require a written request to be made. A tenant should check what the tenancy agreement states to ensure a maintenance request is made in the correct form. Emergency repairs are defined by the Residential Tenancies Act and include such issues as a serious roof leak, a blocked or broken toilet, and a failure or breakdown of an essential service or appliance for water or cooking. For example, a tenant's stove breaking down would be classified as an emergency repair, as a stove is an essential service for cooking. If a repair is an emergency repair, a landlord is required, within 5 business days of receiving the request, to either make the repair or notify the tenant of arrangements made for the repair to be carried out. These arrangements can include quotes being taken of the repair needed. If the landlord makes arrangements for the repairs to be conducted and notified the tenant of this, the repairs must be carried out within 14 days of the date on which the tenant made the repair request. In comparison, ordinary repairs are all other repairs that are not defined as emergency repairs. For example, an air conditioner not working would be classified as an ordinary repair. If a repair is an ordinary repair, a landlord is required within 7 business days of receiving the request to either make the repair or notify the tenant of arrangements made for the repair to be carried out. These arrangements can include quotes being taken of the repair needed. If the landlord makes arrangements for the repairs to be conducted and notify the tenant of this, the repairs must be carried out within 21 days, the date on which the tenant made the repair request. It is important that a tenant reports any repair and maintenance issue as soon as it arises. In fact, there is an obligation on a tenant to do so under the Residential Tenancies Act. In addition, even if a landlord fails to make repairs, a tenant must continue to pay rent on time. When making a repair request, it is better to make the request in writing and keep a copy for records. If possible, pictures of each repair and maintenance issue should also be taken and kept. If a landlord has not addressed a repair request within the specified time, a tenant can do one of two things. 1. Apply to the Northern Territory Civil and Administrative Tribunal, also known as NTCAT, to have the repair and maintenance issue addressed. Or 2. Serve a notice to remedy breach on the landlord, providing at least 7 days to fulfill the repair request. The last day of this deadline is called the compliance day. If the landlord fails to address any repair issue provided for in this notice within the deadline, a tenant can apply to the NTCAT to terminate the tenancy within 14 days after the compliance date. If a property is deemed to be unsafe or uninhabitable as a consequence of an outstanding repair and maintenance issue, either the tenant or landlord has a right to terminate the tenancy with 2 days' notice to the other side. The tenant can also apply to the NTCAT for compensation for the repair issue not being addressed in the timeframes provided for in the Residential Tenancies Act. The application must be made within 3 years from the date of the incident. A tenant is able to gain free legal advice from the Darwin Community Legal Service's Tenants Advice Service. Tenancy fact sheets can also be found on the website at www.dcls.org.au. Contact with our service can be made on telephone 08 89 82 1111.